established an independent judiciary with authority to interpret the Constitution for us all. The judiciary's wise use of that authority is one of the reasons why the new Constitution has endured. Indeed, it's one of the reasons why devolution has taken the form it has now. The jurisprudence developed over the last 3 iterations of devolution have strengthened our exercise of this great mandate to the people of Kenya, where the different levels and arms of government are increasingly seeing each other as partners and not as competitors, as we saw it especially in the first term of devolution. And we keep saying the national government needs the counties need the national government, the 3 arms of government, the judiciary, parliament, and the executive must see themselves as partners. Of course, this doesn't mean that we always agree with every exercise of the judiciary's authority. There are times that we will disagree with a particular decision. But today I'm very pleased to have listened to the principal judge, Justice Baira Mongaya, passionately mention the judiciary's role in the protection of the vulnerable in society, including children and vulnerable families, which makes me now less worried about the recent temporary orders against our plan to feed 250,000 vulnerable children in Nairobi. And I will be calling you Justice as a witness. Thank you. Despite several decisions that we may not always agree with, looking back on the whole body of the court's work since the new constitution came into force, I think we can all be grateful for the judiciary's good sense. Now, ladies and gentlemen, our counties are collectively amongst the largest employers in the country, and so inevitably we call on you frequently in settling conflicts arising from employment in the counties. The Employment and Labor Relations Court has emerged as an important player in county governance. In particular, you work in interpreting, of course, the laws in the context of the Constitution and registering the collective bargaining agreements between trade unions and the county governments and the public service boards, and supplying checks and balances where there has been non-compliance with the law has been exceptionally important. But even here, I think we can do better. And a major challenge for county governments has been the unprecedented industrial unrest, especially in the health sector. Often the ELRC has held that strikes were not in line with the law, and time and again the courts have implored on parties to exhaust alternative forms of dispute resolution as envisioned under Article 159(2)(c), which has been mentioned by many speakers, including Honorable Murugara and the Chief Justice Emeritus, that emphasize the importance of dialogue between parties to sort out dispute. What I would wish for is a deeper engagement with alternative methods of dispute resolution, of course all this with the advice of the judiciary, so that labor disputes like these can be solved before they ever come to court in a contentious way. And I'm glad to see Robert Duba and more representatives of the trade unions, of course not forgetting Dr. Francis Atwoli. Maimze, thank you for your remarks. We need to do this without sacrificing the rights of either Kenyan workers or the public that they serve. It's a fine line to walk, but I and the fellow members of the Council of Governors would like to try. Let's make sure that we solve these disputes early and with as little fuss as possible. And additionally, and I support the remarks by Jacqueline Mugo of the Federation of Kenya Employers, when she gave an example of a company that had to close down following a judgment made by the court leading to a greater loss of employment. You know, on behalf of county governments, we would implore a greater appreciation of context when making decisions which invariably have huge budgetary implications or a wider ripple effect on other cadres of employees within the public service, Honorable Chief Justice. Right now, counties are struggling with quite a number of unimplementable CBAs and judgments, and we really need to renegotiate. And we hope that we can have, a way to do it alternately out of court, and I'm leading that cause at the council. I want to close with praise and reassurance. The county governments deeply value the work that you and the institution and those who support it do. We appreciate, Honorable Chief Justice, your ardent defense of the Constitution, your defense of the rights of ordinary Kenyan workers, and your defense of devolution. And that is why we're committed, not just to maintaining, but to strengthening our strategic partnership with the judiciary, so that justice may indeed be our shield and defender. And that is why we reaffirm today the MOU between the Council of Governors and the National Council for Administration of Justice, whose objective remains the improvement of the administration of justice under devolution. And that is why ladies and gentlemen, I would like to invite you all to join me in congratulating the Chief Justice and in looking forward to a new era of even closer cooperation between the Council of Governors, the county governments, and the judiciary to protect the rights of workers and citizens in the counties. Asanteni sana na Mungu awabariki.
Thank you very much, Governor Sakaja. When we sat the governor at the back there, we didn't ghettoize him. We wanted him to have a very comprehensive view of the high table and the plenary, so that it doesn't evict us from the city. But Governor, thank you. Leadership is about humility and is about service. And thank you for being here and for your speech. Kindly receive the apologies of the Minister, the Cabinet Secretary for Labor and Social Protection, Honorable Florence Bore, who had to attend to an urgent meeting, so she passes her apologies. Ladies and gentlemen, let me now invite the Speaker of the Senate, Honorable Emerson Jeffer Kingi, to make his remarks. Welcome, Speaker.
Respecting the directive given by my former schoolmate, the Honorable Paul Ndemo, I will align myself with the protocols given to us by the speakers who spoke before me, but acknowledge indeed the Chief Justice and President of the Supreme Court of Kenya, the Honorable Justice Martha Koome, and go straight to my remarks. However, before I make my remarks, a friendly advice to my lady, the Chief Justice. When you invite us to these functions, kindly indicate the time within which we should make our remarks, because if you don't, you will run the risk of being entertained into very long speeches like the one you're just about to be entertained into. I didn't get the memo about keeping it brief, and therefore what I'm holding here is a 2.5 speech, 2.5-hour speech, putting in danger not just your health break, but also your lunch hour. I'm indeed greatly honored and pleased to join you this morning for the official opening of this symposium. As you're all aware, this event has been organized by the judiciary under the distinguished leadership of my sister, the Honorable Martha Koome, the Chief Justice and President of the Supreme Court of Kenya, to mark the first decade of existence of the Employment and Labor Relations Court. This is a milestone that we are duty-bound to observe with adulation and great appreciation, given the highly commendable work the Employment and Labor Relations Court has done, and which underlines its position as a critical cog in the wheels of justice in this country. Similarly, this is an ideal moment to collectively review, make an assessment, and pick out operational challenges and hurdles that this court has faced in the last decade and continue to grapple with. We can then seek to address them to enhance the court's efficiency and effectiveness and enable Kenyans reap the intended benefits from its operations as an institution. The noble intention is well captured in the theme of this meeting, namely Employment and Labor Relations Court at 10, the place of Employment and Labor Relations Court in promoting social justice and economic prosperity, and the accompanying sub-theme, that is a decade of encounter with the right to fair labor practices, stakeholder experience. Based on the foregoing theme, I'm fully persuaded that we're in for very robust and enriching engagements that will culminate in practical and actionable resolutions with impactful outcomes. I note with keen interest that a session in the symposium is specifically dedicated to interrogating of employment and labor dynamics in the context of county governments. Topics to be canvassed include principles and practice governing county public service boards and interaction with county executives, evolution of resource practice in devolved governments, and the role of Salaries and Remuneration Commission towards realization of sustainable county public service workforce. As the Speaker of the Senate, which by dint of Article 96 of the Constitution is mandated to offer stewardship to devolution, I greatly commend the symposium organizers for the wisdom that informed this decision. Ideally, it goes a long way in confirming that a significant number of key actors are in sync with the reality that devolution is indeed an integral part of our lives as Kenyans, and whatever governance processes we embrace at the national level must be replicated in the devolved units in fulfillment of the aspirations embodied in Article 6 and the entire Chapter 11 of our Constitution. The Employment and Labor Relations Code is established under Article 162(2)(a) of the Constitution of Kenya 2010 and effectively operationalized under the Employment and Labor Relations Code Act number 20 of 2011. As the apex arbiter in resolving disputes arising in the employment and labor arena, this code has been instrumental in entrenching stability in a fluid labor sector, guaranteeing sustained economic activity and productivity. This has been achieved through a firm commitment to the rule of law and delivery of judicious and timely decisions that have not only placated aggrieved parties, but also expanded our jurisprudence. Permit me to invite you, dear delegates, to join me in commending the honorable judges and judicial officers of the Employment and Labor Relations Court for a job well done, and pray for them to maintain this very progressive and trajectory and commitment in serving the people of Kenya. Tunasema asanteni sana. Kenya boasts of nearly 20 million people in employment in both formal and informal sectors. As we all know, the employment space and work environment remain the theater of an interplay of the interests of key players, namely the employers, employers' caucuses, employees, trade unions, regulatory agencies, and countless other interested parties. The roles of these players are clearly spelled out in the labor laws of our land, namely the Employment Act, the Labor Institutions Act, Labor Relations Act, Occupational Safety and Health Act, and Work Injury Benefits Act. Collectively and individually, these legal instruments give life to Article 41 of the Constitution, which specifies the rights of employers, employees, employers' organizations, and trade unions in diverse work environments. It is these tools that this court banks on as it arbitrates labor and employment disputes that find their way to its doorstep. This notwithstanding, the employment and labor market, as we know it, is persistently evolving with time and in tandem with socioeconomic trends at national, regional, continental, and global levels. It also faces challenges posed by rapid and anticipated technological advancements, global economic recession, geopolitics, emergence such as COVID-19, and lately the adverse impacts of climate change. All these undermine trade and industrial activity, minimize agricultural production, and generally leave us hanging on the precipice of an economic downspin. The net effect has been that in the recent years, thousands have been rendered jobless, incomes reduced, even as we struggle for few limited opportunities in the workplace intensifies. All this coalesce to form a volatile area for industrial and labor unrest and conflicts, and inevitably land in the chamber of judges of the Employment and Labor Relations Court. These circumstances constitute the realities of our time that we must contend and grapple with as we deliberate matters of employment and labor relations and assess the impact of the crucial court in our society. As the arbiter of the last resort in this sector, this court must all times embrace open-mindedness and deploy global best practices. It must continue to uphold the rule of law, which is the sole guarantee that as litigants leave the arbitration table, none feel shortchanged. This is because at the heart of the work of this court lies the element of relations, which it must strive to nurture and sustain at all times for the well-being of the parties involved. The point I'm emphasizing here is that arbitration must always be fair, impartial, and objective to ensure tranquility prevails even after the verdict has been rendered. And to underscore this particular statement, allow me to share with you words taught to us. When I say us, is the class of '98, and I can see some of us here. I can see Manduku, I can see even Justice Brian seated next to me here. When PLO was teaching us the importance of not just this court, but the judiciary, these are the words he used. That as government, mediocrity has no place anywhere in government, be it in the judiciary, in the legislature, or in the executive. But in the unfortunate event that mediocrity finds itself in government, then let it find itself in the executive or the legislature. It must not find itself within the judiciary. And PLO goes ahead to say, as a society, we can do with a mediocre legislature, because then the judiciary will be there to correct those mistakes. And as a society, we can do with a mediocre executive, because then the mistakes by the executive will be rectified by the judiciary. But we cannot do with a mediocre judiciary, because then who corrects the mistakes of a mediocre judiciary? And that's why, as the labor and the judiciary takes its place, there must be no mediocrity within its ranks. Ladies and gentlemen, as I conclude, allow me to affirm that as Parliament of Kenya, we remain fully committed and ready to undertake legislative interventions that will provide encourage to measures needed to enhance harmony at the workplace for sustained economic activity and productivity. With regard to county governments, the Senate remains diligent in ensuring the right legal frameworks are formulated to address issues of employment, labor, and human resource to diffuse potential conflicts. I look forward to a very insightful discussion and proposals from this forum on how we can undertake this duty together and escalate the benefits thereof. I thank you for your time and wish you a fruitful deliberation during the entire period of this symposium. May God bless us all.
Thank you very much, Speaker. We may revise PLO, though. A developing country cannot afford a mediocre elite. Otherwise, it will forever remain undeveloped. Now, after listening to the Speaker of the Senate, and when he said he had 2.5 hours speech, I was about to say, order, Mr. Speaker, order. But you shortened it. Thank you very much. Let us put our hands together and invite the Deputy Chief Justice of the Republic of Kenya and Vice President of the Supreme Court of Kenya, Honorable Lady Justice Philomena Mbetemwilu, who will give her speech, and subsequently invite the Honorable Chief Justice to give her keynote address. Welcome.
Good morning. That thing about protocol will be broken in the following manner. The Honorable the Chief Justice of the Republic and the President of the Supreme Court, the Honorable, no, it's not just called Honorable, it's called Right Honorable, I think, the Speaker of the Senate, the Honorable Mr. Justice Maraga, under whom I served for 4 years. Thank you for being here for us. The honorable judges here present and all our partners. I just feel nice being here. Very nice indeed, because this court with which I am associated deals with that sensitive matter of employment. That matter where if you touch, you're touching not just the person affected, but a whole chain of persons. It feels nice to be here because today you're not 10 years old. In fact, on the 12th of July 2012, 12th of July 2012, the court as is currently known was born. And therefore, on the 12th of July last year, you turned 10 years old. And so, happy belated 10th birthday, my fellow judges on the court. And congratulations for starting the first year of your next 10 years in the great journey of serving the employment and labor relations issues in our republic. Today is a momentous day and occasion as we hold the first Employment and Labor Relations Annual Symposium and exhibition. This year, the symposium forms a part of the ELRC at 10 commemorations and provides us the timely opportunity to reflect on the unique role this specialized court has played in the dispensation of justice over the past 11 years, and how this can be further improved and strengthened going forward. The ELRC has a unique place in the administration of justice with its specialized jurisdiction to deal with matters concerning employment and labor relations. Through your judgments and rulings, this court has gone a long way towards promoting a more equitable, fair, progressive workplace for employees and employers as well. The importance of this role cannot be gainsaid, and there are very good reasons why the drafters of the Constitution of Kenya 2010 felt the need for there to be a specialized court on employment and labor relations. Harmonious industrial relations and a conducive work and business environment are central to our individual and national development. The symposium theme, to wit, the place of the Employment and Labor Relations Court in promoting social justice and economic prosperity, recognizes this very critical connection and thus the importance of the work of this court. The judiciary's strategic vision, the social transformation through access to justice, emphasizes a people-centered justice approach that places the justice needs and justice problems of our country and faced by our people at the center of the administration of justice. It recognizes the multiple avenues through which Kenyans access justice and the agency of the people, workers, employers, and their representative organizations and institutions as justice actors themselves. Over the next four days, and as you deliberate over the very rich program that you have, I urge you to reflect on the place of the court and all its key stakeholders in relation to the STARGE vision towards developing realistic, contextual, and sustainable strategies through which dispensation of justice in this critical area can be substantively improved. I further urge you to engage, to learn, to share jurisprudence, to share experiences, ideas, and best practices, for it is through the cross-fertilization of these ideas, innovations, approaches, that our legal processes, frameworks, and jurisprudence on the issues of employment and labor relations will be improved. I thank you very much. One, for listening to me, and two, for being here for the judiciary of Kenya, and more particularly for the ELRC at 10, at 11. I stand in the privileged position of having to welcome the Honorable the Chief Justice of the Republic of Kenya, the Honorable Justice Martha Karambu Kome, to deliver the keynote address and to start us off from the first symposium of this great court and to future engagements. The Honorable Chief Justice Martha Karambu Kome and the President of the Supreme Court.
Thank you very much, my sister, the Honorable Deputy Chief Justice and Vice President of the Supreme Court. I also recognize the galaxy of distinguished speakers and obey the rule that we save the time. Recognize our Speaker of the Senate, our Governor, our CJ Emeritus, and all the distinguished participants here this morning, or is it afternoon. We honor you, we respect you, and recognize the role that you play in the labor movement, and we are absolutely grateful that you have come to support us as we celebrate ELRC at 11. I think my problem is bigger than the Honorable Justice Dr. Wanjara, because I come to speak even after more speeches diluting mine. I was completely blown away to hear that this court, I thought I was so old, is even older than me. And most of us, thank you, our brother Hattori, for giving us that historical perspective. And thank you all the speakers, as I sat there and heard you say, this is our court. It's the court for the employers. It's the court for the employees. It's the court for all of us. I wish we could say that about all the courts. So this morning, I have the joy to join all of us to commemorate a decade of employment and labor relations court that has now firmly established its place as a crucial driver of the social transformation aspiration that lies at the heart of our constitutional democracy. I join everybody else to congratulate the ELRC for reaching this milestone and for the remarkable achievements it has made in the past decade. 10 years ago, when ELRC was established as one of our superior courts, it embarked on a journey of finding its footing within our constitutional system. Since then, and over the whole decade, it has emerged as a beacon of fairness that addresses the evolving complexities of the modern workplace and protects the rights and interests of both the employees and employers. The ELRC, in its 10 years, has been more than just a court. It has been a catalyst for change. It has been a driver for the social transformation envisaged in our Constitution. It has not merely interpreted the law, but has developed a very unique indigenous social justice jurisprudence that fits the distinctive dynamics of our society and the modern workplace. The court has opened the doors to transformative justice in the workplace. Distinguished ladies and gentlemen, the theme of this anniversary celebration is the place of employment and labor relations courts in promoting social justice and economic prosperity. This theme reflects the core mandate of the Employment and Labor Relations Court, which is to uphold the dignity and the rights of workers and employers. It is also to foster harmonious industrial relations and to contribute to the social and economic development of our nation. The court has also contributed to economic prosperity by creating a stable and conducive environment for industrial relations. It has done this by facilitating dialogue and cooperation between the workers and the employers. The court has interpreted and applied our Constitution. It has also done so to our Employment Act, the Labor Relations Act, the Labor Institutions Act, and all other relevant laws in a very progressive and purposeful manner, taking into account the realities and the challenges of our labor movement. In this regard, allow me to highlight just a few examples of jurisprudential contributions by the court to our growing body of social justice jurisprudence. Some of these include the recognition of domestic workers as employees entitled to minimum wages, to social security, and other benefits. The second one is the declaration of unfair dismissal and award of compensation for employees who are terminated on account of their HIV status, on their pregnancy, disability, or even religious faith. The third one is the affirmation of the right to collective bargaining of workers. The fourth is the enforcement of occupational safety and the other standards and compensation for workers who suffered injuries or diseases at work. The fifth is the promotion of gender equality and non-discrimination in employment opportunities, remuneration, and career progression, including the abolition of sexual harassment in places of work. The sixth is the resolution of disputes arising from restructuring, privatization, and outsourcing. Ladies and gentlemen, these are just a few examples of the many cases that demonstrate that the court's commitment to uphold social justice and promote and protect human dignity in the world of place is their priority. They have demonstrated that the court has become a beacon of hope in the labor market. It is making a positive difference in the lives of many workers and many employers. As we reflect on the journey of the last decade, one thing that stands out for this court is its unwavering commitment to service delivery. With an impressive case clearance rate of 168%, which we corrected in the third quarter of 2022-2023 financial year, that is between January and March 2023, the performance of this court was 168%. This tally distinguished performance has also reduced the backlog of cases in the ELRC by 18%, and the court has proven itself as a beacon of efficiency. These are not just numbers, they are testament to the court's relentless pursuit of the goal of a court of excellence. This court has signaled to our citizens that their quest for justice will not be stalled by backlogs, but will be expedited with fairness and expediency. I urge the court to continue with this positive trajectory and prioritize the 2,200 cases that have been pending in that court now over 3 years so that they can be brought to resolution by December this year, and the court can be operating now within real time, that every case filed cannot be in the court for more than 1 year. But the ELRC has not stopped at efficiency. It has also pushed the boundaries of justice delivery by embracing the multi-door approach that we are championing under the social transformation through access to justice. It has recognized that justice can be achieved in multiple ways through mediation, conciliation, and other traditional justice systems. This diverse approach has not only made justice accessible, but also helped to resolve disputes in a timely, amicable, and cost-effective manner, thus saving time and resources for both the employees and the employers. Moreover, the court's proactive adaptation to technology is a testament to its forward thinking. Embracing virtual hearings and e-filing, the ELRC has ensured that it leverages on technology to enhance accessibility, efficiency, and accountability. In a tireless effort to increase access to justice, we have extended the reach of ELRC across the breadth of our nation. Today, we have 10 ELRC court stations, 3 of which are regularly served by visiting judges, and an additional 11 sub-registries. This increasing footprint of the court is a testament to our people, to our pledge to bring justice closer to the people, to ensure that every Kenyan, no matter where they live, they have access to fair and impartial hearing and a judgment. Recognizing the considerable volume of cases emanating from Nairobi, as the principal judge has said, we have taken decisive steps to accelerate service delivery in the capital. We have established 3 divisions of the court: the Judicial Review and Labor Rights, the Appeals Division, and the Claims and Labor Relations Division. This strategic decision allows the court
KTN News. Get the whole story.